Welcome everyone to the first session, and welcome back to those of you who had been with us at the first four events, and welcome to this and all future ones to those of you who have come for the first time to this one. The series of conferences is really evidence of what I suppose you might call living originalism. And I'm extremely pleased to introduce David Upham's paper, which I thought was a fantastic paper. It's, among many other things, evidence of the extraordinary 19th century American political tradition of rigorous thinking and muscular expression. As I read the paper, I thought to myself, Abraham Lincoln's own intellectual and moral clarity, which seems almost miraculous, seems perhaps a little less so when you're confronted with the legal and political culture of the American 19th century, which David confronts us with. That Lincoln, for all his extraordinary quality, didn't come out of nowhere. So David will speak, and then Jack will comment. David.
I'm distributing, and I apologize for not making enough copies. I've obviously underestimated the attendance, but this is a very a supplement to the presentation that might be of use during subsequent conversation. Well, good afternoon, everyone, and to say the least, I'm extremely grateful for the opportunity to present my work before such a distinguished group of scholars, and I am very grateful to the Originalism Center for giving me this opportunity. I thank everyone for taking the time. Those, I assume all you more or less read the paper, and I thank you for doing so, and especially thank you to Jack Balkin for taking the time to read it and for agreeing to offer some comments. In particular, this might go without saying, but I would be very grateful for any notice of any gross errors or omissions. Much of the material I'm working with here is new. I tried to be as comprehensive as I could in including all the significant relevant evidence. I think I reasonably fear that I missed something. I think I also reasonably fear that I might not have been totally fair with some of the evidence. So I'd be grateful in advance before publication for for a little bit of errors and omission and insurance ahead of time. Let me just, during the few minutes I have here, cover three topics. First, how I came to the paper, summarize the paper, and lastly, say a few words about the relationship between the working hypothesis I use in the paper and the evidence I find, and the relationship of that to the broader topic of what did the Privileges or Immunities Clause originally mean. I came to this paper by force of my doctoral dissertation work, which I began way back before the turn of the century, and which I started looking at again a few years ago around the time of the McDonald case. Well, the McDonald case was decided, and I hadn't published anything, and I said, well, that's just great. And I still continued working on this, and then about maybe 2 years ago, the marriage litigation started to accelerate. And I knew that I had seen enough stuff during the course of my research to say something relevant about the so-called loving analogy. So I decided to focus on this particular subtopic of my hoped-for, planned-for opus magnum on the Privileges or Immunities Clause. The article has 5 parts and a concluding part, and I'm just going to read briefly the summary that I found put in the abstract and in the paper. Part 1, contemporary originalists have not, in my opinion, provided a persuasive account of the inconsistency between state racial endogamy laws and the 14th Amendment. And I particularly criticize a recent paper by Professor Calabresi and Andrea Matthews on the subject. Second part, that before the amendment, most, but not all, authorities concluded that such laws abridged a pre-existing right recognized at common law, which right represented a privilege of citizenship. Third, during the adoption of the amendment, both proponents and opponents generally, though not unanimously, declared, acknowledged, or conspicuously failed to deny that the amendment would invalidate such racial endogamy laws. Fourth, that contra the Supreme Court's claim in Casey, and in fact the more emphatic argument of Virginia's attorneys in Loving versus Virginia, within 5 years after the amendment's ratification, these laws were either non-existent or unenforced in a clear majority of states, including a supermajority of states that had ratified the amendment, in large part because Republican officials, including virtually every Republican judge to face the question, concluded that African Americans' rights under the 14th Amendment precluded the making or enforcing of these laws. Fifth, that the contrary holdings were made with seeming unanimity or close to unanimity by Democratic judges hostile to Reconstruction, whose hostility was frequently manifest in their implausible interpretations of the amendments. Finally, in the concluding part, I argue that the Supreme Court's decision in the slaughterhouse cases dealt a serious blow to the amendment's original meaning and facilitated, although it was by no means the only cause, but it was an important cause to facilitate the renewed making and enforcing of these laws in the southern states and in the western states. I conclude the paper by saying that the history proves by a strong preponderance of the evidence that the 14th Amendment, as understood by the citizens that proposed, ratified, interpreted, etc., precluded the enforcing of these laws, at least insofar as they prevented interracial marriages between citizens of the United States. I use the term strong preponderance. I was tempted to say clear and convincing, but I didn't think it was quite clear and convincing enough. There's enough evidence out there to say otherwise. And in particular, both the antebellum and evidence and the evidence during the debates and ratification, I think can be summarized in this way. Opponents of black citizenship, when they spoke of the issue, said with unanimity that to grant African Americans, I should say, to grant free blacks the status and privileges of citizenship, thus making them African Americans, would in fact would require that these laws be invalidated. Supporters of black citizenship before the Civil War were divided. Some said, no, it wouldn't be a problem because these laws are equal. They have a kind of formal equality because whites can't intermarry with blacks and blacks can't intermarry with whites. But I think that probably certainly the most enthusiastic advocates of black citizenship, agreed with the opponents. A similar pattern, but a slightly more anti-racial endogamy pattern emerges during the framing and ratification. Opponents of the amendment, when they spoke on the subject, unanimously said that these laws would be abrogated, with one exception. The North Carolina legislature said that it might happen. They said it wasn't the most likely thing, but these laws might get abrogated. While supporters of the amendment generally, oftentimes were just silent, some said yes. Some said yes in a very indirect way through their interpretations of the existing Civil Rights Act. But there were some that implied through their actions, and I'm sure if I could dig deep enough I could find the express statements, implied through their actions that they did not think that the amendment would abrogate these laws. And now just a few how many minutes do I have left? Okay, good. Just a few comments on, I'll take those few minutes for a few comments on the relationship between what I assert as a hypothesis and the evidence in the paper, and its relation to the broader debate over what this original Privileges or Immunities Clause meant. From my standpoint, it's not so much a hypothesis, it's something of a thesis because I've worked on the antebellum evidence a good deal. My hypothesis on the piece of paper I gave you is closest to 2C. Okay. That is, that the 14th Amendment's Privileges or Immunities Clause was intended to enforce Article 4 privileges and immunities, understood as certain fundamental rights that had been long recognized by the several states since the time of their becoming free, independent, and sovereign. What I would call the extended and completed Corfieldian list. As to the first category, 1A or 1B, which is the category that says these are separate privileges. My hypothesis obviously does not agree with that. The evidence I see, I think, does not support that conclusion. for the following reasons. During the post-ratification court cases and debates, had that been a predominant understanding, opponents or friends of racial endogamy laws would have made those arguments. They made them with gusto after Slaughterhouse. Before Slaughterhouse, before circa 1871-72, those arguments are not made. The first time it was made, to my knowledge, in a court of law in any case, was in the Lonis case in Tennessee. And in that case, the Tennessee Attorney General made the argument. The Tennessee Supreme Court still upheld the laws, but said, no, it's Article 4, it's Corfield, and they had their own interpretation of Corfield. As for the various species under the genus Article 4 is enforced by Amendment 14, the idea that Article 4 as enforced was simply an interstate equality reading finds little evidence, save in Judge Erskine's opinion in Ex parte Hobbs in 1871, upholding Georgia's racial endogamy law. I think the evidence in other respects, with which many of you are familiar, points to the conclusion that the Article 4 equality that the authors of the 14th Amendment had in mind included interracial equality and perhaps other significant equalities. The Part C, as I said, is my tentative thesis. It's also my hypothesis for purposes of the paper. Is not surprisingly largely confirmed. If it wasn't, I would have changed my hypothesis and rewritten the paper again. The last interpretation is that Article 4, so enforced, incorporates certain fundamental rights, but subject to addition or perhaps even subtraction by changing conceptions of human dignity. I don't find significant evidence to support that, but I would like to make a comment about what that would say for racial endogamy laws under the Privileges or Immunities Clause. As indicated in the paper, I'm hung up on the word privilege, immunity, citizenship. And does the words themselves suggest to me that in analyzing those particular rights, some attention must be paid to citizenship and its privileges. As I mentioned in an email to Mike Rappaport, the word immunity implies a munitas, implies somebody who the burden can be imposed on. And if there's an immunity of citizenship, that means non-citizens, at least in theory, could have these burdens imposed on them. Now, one of the problems with the Privileges or Immunities Clause has, in my opinion, has been that over the past maybe 200 years, really, since before the Civil War, in American law, and in fact international law, the distinction between aliens and citizens has been diminished. And the idea that certain things only citizens should get, or if aliens get them only as a matter of indulgence, those rights have diminished and to a certain extent come out of existence. So, for instance, the Universal Declaration on Human Rights says that one has a right to marry regardless of race and regardless of nationality. So international, interracial, all of these endogamy laws have to be swept away as a matter of fundamental, universal human rights. The effect of that, I think, has been to obscure the degree to which the Privileges or Immunities Clause might have a substantial meaning. We're not accustomed to saying, like the state constitutions of the founding era said, that the right to bear arms belongs to citizens or the people, or the freedom of speech or the press belong to citizens or the people. But the more our standards evolve, in other words, to expand the category of human rights, to that very extent our standards evolve to contract and almost maybe destroy the category of privileges and immunities of citizenship. That might seem kind of ironic. We tend to think of evolving constitutionalism as searching out for new liberties and rights. But if the principle of evolution is to be applied to the words privilege, immunity, citizen, then to a certain extent they don't exist anymore, except maybe you get to have wear the name tag, citizen. And you get to enjoy one of, but by no means all, of the necessary conditions, one condition for political rights, voting rights. All right, thank you all very much.